William, thanks very much for your time. Let's talk a little bit about the, shall I call them, the peculiarities of child witnesses. What do children, and of the age we are talking about here, sort of tend to do when, they have to come forward with testimonies of what would have happened to them?
Good evening. The issue of children as witnesses has been a problem for a long time. As a result, the Criminal Procedure Act allows children to give evidence in a courtroom where through CCTV or closed-circuit television and with an intermediary present to be able to assist the children while testifying. Obviously, children have to be dealt with in a particular way in respect of criminal cases. The prosecutors need to sit with the children and explain to them that it's very important to tell the truth. The presiding officer must also determine that. So in instances where you have children as witnesses, a court must regard the evidence with caution. And if there are contradictions in the evidence of, let's say, one witness, or with one witness as against another witness, then the court has to take that into account, particularly where there might be an allegation of that witness beforehand being told what to come and say. But it is not a very pleasant experience testifying, even for children that are a bit older. But if you're talking about children who are 10, 11 years of age, it is a very, very difficult and traumatic experience. And, courts must understand that.
Now, just take us through, for people who don't know how these children get prepared for what you are saying is, in fact, a very difficult situation. What then goes into that preparation? You said, you touched on the importance of telling the truth, but how is it done? And what are the things that the people who coach them actually try and drive home? And perhaps more importantly, how do they do that?
Well, I don't think it's a question of people coaching a witness. It's merely that people assist the witness to explain what is going to happen in a criminal trial. So let's say a complaint is laid. A child tells his parent or family member that an incident has happened of sexual assault. They go to the police and a statement is taken. That child must be interviewed by a social worker or psychologist that is attached to the police. And that must be done in an objective manner. So that particular expert must make sure that the child knows the difference between the truth and telling a lie, and to be able to prepare the child to go to court. In court, the child will have to deal with a prosecutor in the sense that the prosecutor will sit with the child and prepare the child to give evidence, but to make sure at all times that the child is not lying. Because, one can't have evidence presented to court when the prosecutor feels that there may be inconsistencies and discrepancies. So the prosecutor will prepare the child at court. We have sexual offences courts, specialized courts dealing with cases like this. You'll also have a social worker who is there to prepare the child, explain to the child what's going to happen prior to that child having to testify in court. During the court trial, there are also safeguards because the magistrate or the judge must make sure that the child is telling the truth. There's a prosecutor and there will be defense counsel questioning the child, and that must all be done in the proper and correct fashion. So during the trial, there's an intermediary that assists the child, and it's dealt with through the system of closed-circuit television. So the child isn't in direct contact with the alleged perpetrator.
Who are these?
But what is important...
Yes, okay, continue them.
Is that the truth must come out. No, that the truth must come out. So you can't have a system where the child is told what to say.
Now, who then are these intermediaries? What specifically is their role, and what are their qualifications for being there as intermediaries?
So they'll be either social workers or, in some instances, former teachers. They have to do a course with regard to becoming an intermediary. And these are all regulated by the law. You can't just have anybody appointed as an intermediary. That person then assists the witness and will explain issues that might be problematic or the witness doesn't understand. But that is all done on closed-circuit television, so the judge, the prosecutor, the accused, and the legal defense has a view of what is happening, although it's in a separate room, and can see if there are any irregularities being committed. But that person is merely there to literally repeat what a witness has said and to explain to the witness if there are any problems with understanding questions, not to coach the witness at all.
Now, during this process, William, whose job is it to make sure that throughout and every step of the way, the interests of justice are paramount? In other words, whose job is it to make sure that you don't perhaps overly promote the interest of the children because you may have a bias, but you need to ensure who makes sure that the interests of justice are what is paramount?
I think before answering that question, one must make it very clear that everybody is entitled to a fair trial in terms of our Constitution. So ultimately, the presiding officer, be it a regional magistrate or a judge, has to determine that the case is dealt with fairly. The prosecutor, I believe, also has a role to play in seeing that justice is done. So if that witness has gone and told the prosecutor something that he or she is only aware of, changes in testimony, then in advance, then that must be disclosed to the court. And then obviously legal counsel, the accused's defense, has also got a role to play to ensure that justice is done. But at the end, it's the judge, has got to make the decision, has to ensure fairness, and obviously if there's a conviction, has to deal with the sentence. So he or she is the person in charge of making sure that the court runs according to the principles of our law and according to our Constitution.
Just before I let you go, William, a lot of people criticized the judge for looking strictly at the people who actually made this case to fall flat, the NPA and so on. In situations like these, from previous experience, what have other people or judges or presiding officers done in situations like these to make sure that where the children may have been let down by the people who were supposed to look after their interests, the case doesn't collapse? Or is appeal the only way to rectify that?
Well, with regard to an appeal in a criminal case, the state can only apply for leave to appeal on a legal aspect, not on the facts. So the judge must make sure that the prosecutor is obviously doing the matter in an objective fashion, doing his job. So if there's criticism of the MPA, obviously that can be dealt with in a different forum. There may be a disciplinary inquiry against the prosecutor if there are comments by the judge that the prosecutor has not fulfilled his function. So, you know, I mean, I suppose the children, through their parents, can complain and lodge formal complaints with the MPA that will have to deal with it, or take the matter to court as a civil action against the MPA, if there is evidence, obviously, that the MPA have let the children down, as you say. But at the end, every case is as good as its witnesses. So if the witnesses contradict one another, they change their stories, and they're not credible, bearing in mind the cautionary rule that there is with children, then unfortunately that is sometimes a cause of the case collapsing, and maybe the witnesses have not told the truth.
William, thank you very much for your time and insights this evening. I'm sure we haven't seen the end of this particular matter.